When you separate, there are so many questions and so much uncertainty. Can I still live in the house? How will I support myself? How can we divide our assets? These are all valid questions. For parents, however, the questions are even more pressing. Who will the children live with? How often will they see the other parent? Who makes the decisions regarding their future? My name is Lisa Nguyen and I am an accredited specialist in family law. When clients come to see me at McLaren's, the very first question they ask if they are parents is usually, who gets the kids? Understandably, it is an issue of real concern and one that many couples struggle with after separation. Most importantly, the needs and best interests of the children should remain at the forefront of any discussion. There are also options that can make life a little easier and provide clarity and routine for children when their parents no longer live together. The first option is to negotiate a parenting plan with your former partner. A parenting plan is an informal agreement that covers important issues such as who will the children live with? How much time will they spend with the other parent? Is it a week-about arrangement or an every second weekend split? When does overnight time commence? How will parents share the decision-making for important matters that relate to the children? How will parents resolve disputes or address future concerns which arise for matters relating to the children? A parenting plan is usually negotiated between the parents when they separate, then written down and signed by both parents. It can also be easily updated through agreement by both parents. It is flexible enough to accommodate changes. For example, if one parent needs to swap a date, new dates can be agreed to by the other parent. The plan is not enforceable by law. However, it does provide structure and routine for the family. Since a parenting plan is also signed and dated by both parties, it can be used as evidence of a previous agreement between parents to prove their willingness to work together. The second option is to seek parenting orders. These are similar to a parenting plan in that they contain orders about who will be responsible for the decision-making of matters which relate to the long-term welfare of the children, which parent the children will live with, and how much time they spend with the other parent. However, orders are usually negotiated and documented with the assistance of a family lawyer, and once an agreement has been reached, they are filed with the court to be made into consent orders. Importantly, consent orders are enforceable by law. This means that they cannot be changed easily and that there are consequences for non-compliance. For example, if a child is meant to be dropped off at the other parent's house at 5 p.m. on a Friday and it doesn't happen, the court could impose a penalty on the non-compliant parent. For some separated parents, reaching an agreement on parenting arrangements for their children is not easy. In these cases, your lawyer might suggest family mediation as the most appropriate way to discuss issues of concern and ultimately reach a solution. In fact, attendance at mediation is compulsory before any parenting matters will be considered by a court, and couples must show evidence of their attempts to resolve their disagreements through mediation. Remember, it is always in the best interest of the children to try and resolve parenting issues as quickly and effectively as possible, with as little conflict as possible. The goal is to minimise the impact of separation and divorce on the children and allow them to develop a healthy relationship with both parents, providing it is safe to do so. If you are experiencing a family breakdown and have questions concerning parenting arrangements, contact McLaren's lawyers today for practical, easy to understand advice and assistance.